Anthropocene. This is the current geological epoch where human activities have had such an impact on our planet that they are classified as a geological force in our own right. And us, all of us seated at the table here, we are not only the first generation who will have to deal with the impacts of the Anthropocene. We might be the last generation to really do something. And so, in many ways, the future of environmental law is in our hands. And in recognizing that, we also need to recognize, number one, that environmental law by itself cannot address the planetary challenges that we face. And number two, that in order to address the future of environmental law, we must recognize the giants on whose shoulders we stand. And so it gives me great pleasure to have here today to provide opening remarks, the link to the rest of the solutions for our planet, and one of the giants of environmental law. So first up, we have Justice Antonio Herman Benjamin, and then we will hear from Inga Anderson. It's my great pleasure to have both of them here, and often you hear people introduced as requiring no introduction, and then they are then introduced that way. Antonio requires no introduction whatsoever, and so I shall pass over to him. Thank you, Antonio.
Good morning, bon dia, buenos dias, bonjour. That's all. Good morning. I'm delighted to assist in opening this first colloquium with the young professionals of the World Commission on Environmental Law of IUCN. And if you ask me whether I would envision this 10 years ago, I would probably say no. As all of you understand, law is based on seniority. And here we have the giants of environmental law all standing back there, and all the seats taken by the young professionals. So it's already the symbolism of the city, and the symbolism sometimes is expressed in very nuanced manner, but they are there, and I would like to stress this symbolism. We are here not to speak, we are here in fact just to say that we are delighted that you'll be speaking, that you'll be discussing the future of environmental law. I would like first to thank Michelle Lin and Nick Briner. They are sitting in the center. All my colleagues from the IUCN Secretariat, and I express my gratitude to them and to the DG, Inga Anderson, that I know is even more happy with this event than I am. And also my gratitude to all of you that accepted to come this morning, although we understand that the invitation is not for the whole hearing today. We'd love to be here the whole day, but we are most welcome, I understand, from Michelle and me during the opening and then Bishop until 11:15. So this is the curfew for us. At 11:15 we have to go. So let me thank, as I said, the giants of environmental law that are all standing here from Brazil and from many parts of the world. And again, just to say that could not have a better beginning the first IUCN World Environmental Law Congress, then beginning with you that will take the lead, not just in developing new ideas, but also making sure that the compliance and enforcement gap that we face in environmental law will be faced. That's the present need, or the most urgent present need. With that, again, thank you all. Many thanks to the Office of the Attorney General that offered the Collegio chamber for that. They had a meeting scheduled for today of the Collegium, and they didn't cancel. We have postponed it. They canceled, so you could meet here today. So thank you very much, and I wish you all a fantastic, productive meeting. With a lot of, there is a lot of hope for what is debate. Thank you very much.
Now my great pleasure to invite Inge Anderson, the IUCN Director General, to say a few words.
What can I say? We were welcome to the Anthropocene. Let me first say to Michelle and to Nick and to everyone here from the young professional in the WCO, bravo to you. This is such a great opportunity and such a great initiative. And for my part, I've just been talking about how do we get young people into the environmental movement. It is a graying movement, it is an aging movement, and then to walk in and we begin with this. How wonderful is that? And as a woman who have worked for 35 years in professional hairdressing, I couldn't help but do a little count. Because environmental law and law is a male-dominated field. But when I look at who's sitting on the bench here, I'm so pleased to see that we have such a strong group of young men and young women. Bravo to you all. You are the future. We're done. We're done. And what we have done as a people, as a species, is not exactly good. So what we're going to be leaving you, you might not thank us for it. Which is why the fact that you're organizing now, which is why the fact that you're stepping in, which is why the fact that you're networking, which is why the fact you're seeking solutions matters so much. And so I wanted to share with you just a few words because Michelle, you mentioned the Anthropocene. And it is true that we are, in a sense, pushing against the very planetary boundaries of our planet. We are putting things into the atmospheres, into the waters, we are extracting things from the bottom of the oceans or throwing things into the oceans, extracting ourselves into a state where our very existence, our very footprint is determining the future of this planet. And never before has that been the case. We are, as you said, Michelle, shaping that planet. And imagine that. Human beings actually having an impact on whether icebergs melt or not, whether oceans rise or not, whether people will be flooded or not, whether there will be plagues and famines, etc., because of ecosystem shifts or not. That is the time in which we live, that Anthropocene of which you speak, Michelle. And so that puts upon us at this time, in your generations, in our time, it puts upon us an extraordinary responsibility. A responsibility that is frightening, a responsibility that is incredible, a responsibility that is heavy, but a responsibility to which we will stand up. And when I see you in this room, I know you will stand up to this too. So we are here now at this time, just as we are heading towards Hawaii with the Planet at the Crossroads tagline for the Congress in Hawaii. And I'm speaking about this because this crossroads is very real. But I don't want you to think, oh, it's all hopeless and let's just go home and, take care of business and enjoy a good life. No, because this is not hopeless. Because we know that we are at this time where what we do or don't do will forever impact the future. But there are things that we can do, and that is why I want you to reject the pessimism. I want you to reject the hopelessness, because that is not so. There are solutions, and if you just take a quick look in the rearview mirror and think of 2015, and think of how the world stood up, and think of how we had agreements in Sendai on disaster risk mitigation, in Addis on financing, in New York on the Sustainable Development Goals, in Paris on the climate agreement. Look at that. That's multilateral law at its finest. That is engagement of leaders across the world at their best. And that is what you now have to lead forward. There was a sense that multilateralism was dead. It is not. It is alive and kicking, and you are the future of it. So that's why we say that, lots of good things have happened on this earth. If you think back 2050 to now, we've seen life expectancy exceeding by 25 years. That's a massive achievement. If you think back to the 1990s to now, poverty has been cut into half. If you think back 100 years, all these good women here couldn't vote. So lots of things have changed, lots of things are improving. And now we need to make changes in the environmental story. And the story is happening and changing as we speak. And obviously a strong legal platform, a strong role of law, national work, even state level enforcement regulatory frameworks at the national level in terms of national frameworks and strong judiciary, and at the global level in terms of all the conventions, etc., that we have signed. And so the work that you do and the work that we're doing now is absolutely critical. So these were really the messages that I wanted to give to you now. I want to give you a sense of urgency. I want to give you a sense of choice. What we do or don't do matters in our personal lives, in our professional lives, and the manner in which we lead. And I want to give you a sense of the possible, a sense of optimism. Thank you very much for inviting me.
Good morning, bon dia. It's such a great pleasure to be here among so many of you, so many friends and colleagues, and many of you that I don't know yet, but I hope to get to know. It's a great privilege, and we've been so pleased and honored with such great participation and such great interest from all of you to come to this colloquium. I want to especially thank the Ministerio Público and all those who have helped with arranging this. And thank you very much to both Justice Antonio Benjamin and Inger Anderson for those very insightful comments, and I think very hopeful as well about what we can accomplish. So just to explain for a brief moment about the somewhat unusual format, Michelle and I were so pleased and delighted with such great responses that we got from so many of you that were interested in speaking at this event. We have what we're calling speed presentations, so they're going to be very brief chance for us to just really get to the heart, the very core principles of what the new generation thinks is important for the future development of environmental law. So we've asked all the presenters to keep their remarks as brief as possible, to 3 to 5 minutes, so we have a chance to hear from everyone. It's really just a great diversity and richness of experiences and perspectives from all the people here on the table. So I'm very much looking forward to hearing from that, and we'll sort of dispense with the usual introductions, but everyone can come up here to the front, and we also have videos from a few people who were not able to make it here with us today. But we'll go ahead and get started with those, and yeah, we'll follow the order that's in the program, so thank you.
Here, next to me. We are from the Environmental Law Center in Bonn. Thank you very much, and thank you for your assistance. So my name is Caitlin, and this is Lydia, my colleague. We're from the Environmental Law Center in Bonn. Our director is here with us today as well, Dr. Alejandro Iza, who's standing there. Thank you very much for supporting us today. We're very much looking forward to the presentations of all the young professionals here with us today. We've been asked to address 3 questions for which we are to set the scene today. and after that, my colleague Lydia has a little surprise for everyone. I'm keeping the best for last, of course. So the three questions that we've been asked to address today are, first of all, what is the main environmental challenge we face today, or we think that we face today? The second question we've been asked to address is, what are the key legal issues in combating this environmental challenge? And finally, we've been asked what reforms we see fit to address these legal issues. Of course, we've had a discussion in the Environmental Law Center about what we think are the main environmental challenges, so we're very much looking forward to your answers as well and your speed presentations to address those. So generally speaking, our system, and that is not just our legal system, but also our engineering systems, our science systems, our governance systems, our political systems, is not really equipped to deal with the environmental challenges that we face today. And that is because our environmental challenges have become global, transboundary at the very least, long-term rather than short-term, uncertain, cross-sectoral with a distributed impact. We believe that traditionally the environmental laws that were created actually were created to achieve the opposite. Namely, they have been designed to achieve address the single sectoral aspects, site-specific aspects, localized aspects. And the challenge is thus to turn that around and to change the system as to address the issues from a global, long-term, uncertain, cross-sectoral, and distributed perspective. An example of that is climate change. This is a global challenge that we face, yet our laws are created at a national jurisdictional level. So how to address that challenge from a global perspective is a big challenge. What do we see as the current legal issue then? If we look at our legal system, not just engineering systems, governance systems, and so forth, is that our current legal approaches, so within our own discipline, across legal disciplines, are actually not well coordinated to address that system challenge. So that leads me to answer the third question, which is then, is reform necessary, and what kind of reform would be necessary? We believe that actually the whole system has to be rethought for that. That actually requires a systems approach, and our colleagues in other disciplines, engineering and so on, have been very good at addressing that challenge. And I think the way forward is actually a multidisciplinary approach where we give more attention to this systems approach, meaning looking at the interdependence of the internal as well as the external factors that contribute to environmental issues. Now, my colleague Lydia here has a surprise for you. I'm not going to delay it any further.
Thank you, Caitlin. I am not quite as tall as my colleagues. I will try to lower this. The surprise is Ecolex. Surprise, Ecolex. Nick, can you just click on the second tab? So raise your hand if you have heard of Ecolex. Wonderful. If you haven't heard of Ecolex, this is always a surprise to me how few people have heard of it, because it is a wonderful resource that has been around for many, many years, which provides access to a large database of judicial decisions, legislation, treaties, COP decisions, and literature on environmental issues, on environmental legal issues in particular. Now, perhaps the surprise is that for the many years that, the many decades that Ecolex has been in existence, it has not really updated its look. So if you go to Ecolex now at ecolex.org, you will not see this. You will see a slightly more outdated interface. And so perhaps the surprise is that we are updating this interface to try to make it more user-friendly and accessible. Because I don't have time here to really go through it with you and talk through it with you, I want to invite you instead to come visit me during the Congress. I will have a stand where I will have Ecolex on a computer, on a tablet. You can come, you can play around with it, you can see what the new version is going to look like. And we can talk about how you can get involved in populating this database, because this has grown into something that's much more than we at the Environmental Law Center, our partners at FAO or UNEP can do on our own. And we want to reach out to you and to the broader legal community to help us make changes. So, thank you.
Okay, next we have a video presentation from Elise Shakalela from Loyola University Chicago School of Law.
I greet you all in the name of promoting good and sustainable environmental practices. My name is Elisha Kalela, a junior environmental legal officer from Namibia and an LLM candidate at Loyola University School of Law, Chicago. I'm going to be talking about genetically modified seeds versus farmers' rights in the context of Africa. I'll give you a brief definition of what genetically modified seeds are, farmers' rights, the legal challenges, the legal issue, and then I'll conclude. Genetically modified seeds refers to those seeds that have been formed through a process whereby the DNA of one species is taken and possibly placed into another DNA of a plant species, forming a seed which can either be called transgenic and/or cisgenic. Farmers' rights refers to all those rights that farmers from all over the world have been practicing. They are also known as common law rights, which basically include seed saving, exchanging, selling, and replanting the seeds. These rights are also confirmed in the International Plant Treaty on Genetic Resources for Food and Agriculture, which affirms the past, present, and future contribution of all farmers from all over the world. It's also articulated in Article 9.3 of the same Plant Treaty. To highlight the legal challenges, I'd like to share with you a story of my Namibian grandfather. I refer to him as my Namibian grandfather because I have many grandfathers all over the world. My Namibian grandfather tells me that after every harvest, he saves seeds, which seed he would at times exchange for other plant varieties of seeds, which seed he would also sell and give to his or her family members. He also tells me that this practice is not only known to him, but it's known in his communities. Ladies and gentlemen, this practice is known in all communities of Africa. The legal nature of genetically modified seeds does not allow farmers to continue with these practices of seed saving, selling, exchanging. To highlight the legal issue, I'd like to bring to your attention the following cases. In the case of Us Grow Seed versus Venterburg, a 1995 US case, where it was held that farmers' rights are only restricted to personal use where they have used genetically modified seeds. In 1998, the US Patent Office issued a patent known as the Terminator technology, which renders seeds sterile immediately after harvest. This means that farmers were no longer able to reuse the seeds even if they replanted them. In the case of PSC, a Schmeischer case, this is a case where it even highlights that even in the instances where farmers are not necessarily the one who grew these genetically modified crops, but rather a transmission through wind or pollen, they could be held liable to pay penalties or royalties to owners of genetically modified seeds. In Indonesia, farmers are being criminalized for actually selling, exchanging these genetically modified seeds. The same is happening in Thailand. Ladies and gentlemen, this situation could happen in Africa if GM seeds are allowed on an open market. In countries like South Africa, GM products are already available on the commercial market. In countries like Senegal, Morocco, Zambia, Zimbabwe, Egypt, they are actually currently doing field trials and research. I'd like to conclude with a quote from an activist from Kenya, Zachary Makanya, who states that Africa is becoming a dumping site for genetically modified seeds and a laboratory for frustrated scientists. Ladies and gentlemen, let's refuse genetically modified seeds on an open market. Let us invoke principles such as the precautionary principles in order to save farmers' rights and to ensure that extinction of seeds does not occur. We need to define what farmers' rights are in terms of really securing its legal nature. We need to do more research and development in terms of genetically modified seeds so that we can come up with better seeds, those that are not able to actually cause extinction to seeds, neither impede on farmers' rights. Let us also come up with guidelines that are able to guide us in terms of how to handle genetically modified seeds. Thank you.
Thank you all for having me here today. My name is Marina and I'm from the Federal University of Santa Catarina. And my main research topics are the public policies for agroecology in Brazil and their legal implications here in our legal system. So agroecology can be understood as a transdisciplinary science that studies the application of ecological principles to the management and design of sustainable agroecosystems. It is also known in Latin America as a critical theory, a social practice, and a social movement that in general advocate for the establishment of a more sustainable and socially inclusive food production system. More specifically in Brazil, the agroecological claims have been incorporated into a bill that later became the National Public Policy for Agroecology, which established at national level a set of provisions and guidelines regarding the promotion of agroecology. Following that, several new state laws regarding the matter were enacted. In this sense, we can mention some of the most relevant environmental problems related to the matter, which are the multidimensional environmental crisis that we live in, the increased complexity of environmental risks that demand new transdisciplinary approaches and solutions, the current high rates of malnutrition and hunger, and the failure and sustainability of industrial agriculture, which is characterized by intensive use of land, the massive use of chemical fertilizers, pesticides, and genetically modified organisms that have a significant impact on the environment. We can also highlight here a great environmental challenge, which is feeding the growing human population while meeting the fourth dimension of food security, food availability, access, utilization, stability, and achieving sustainability. So within this perspective, the key legal issues of this thematic are the delimitation of the legal implications of the new legislation on agroecology. For example, would there now be a duty of the state to promote sustainable agriculture in spite of industrial practice? What are the legal obstacles for policy implementation? Are the new mechanisms compatible with the existing legal framework? And the analysis of the relationship between agroecology and law. For example, has agroecology in Brazil integrated a law into its perspective and vice versa? Has the Brazilian law been able to review its fundaments in the light of the new agroecological paradigm? So looking to the future, and in order to properly address these previously mentioned issues, some things are needed, such as discussing the interconnections between the new agroecological legislation with the existing laws related to family farming, food security, and organic and ecological production, better delimiting not only the legal statutes, principles, rights, and duties brought to the legal world by these new laws and public policies, but also their extension. And at last, reviewing the Brazilian legal institutes in light of the new paradigm set by agroecology, and also the current division between the quite specialized legal disciplines. So, in brief, this is all that I had to say for today. Thank you all for your attention.
Hello everybody. First of all, I wanted to tell you that I'm really sorry that I couldn't attend to Rio today with you, and I will be more than happy to pursue the discussion after the presentations. My name is Elise Rousseau. I'm from Marseille, and I am a postdoc. My work is essentially to focus on soil protection. I'm an environmental lawyer or researcher. So today I wanted to talk to you about the IUCN assessment on land degradation and restoration, and what outcomes could come out from this assessment to improve the protection of soils. First of all, a preliminary word about the IPBES. The acronym means Intergovernmental Platform on Biodiversity and Ecosystem Services. It's an international science policy platform, the goal of which is to bring independent scientific assessments of biodiversity and ecosystem services into the Convention on Biological Diversity process. Currently, there are 4 regional assessments and 2 thematic assessments. The first one, I'm sure you've heard of it, it's about pollinators, pollination and food production, and it was released in February 2016. The second thematic assessment is about land degradation and restoration, and it's still in process. It's expected for 2018, so it's a lot of work to be done yet. To answer the question of the IUCN Congress, what will be the main environmental challenge for my presentation? Well, in my case, it would be the protection of soils, because the challenge is to improve the protection of soil that is truly lacking of At national and international levels, soils are rarely considered as a natural media by the law. There is a lack of a soil protection status. 8 kinds of threats have been identified by the European Commission in 2002, and they are still not being addressed. These are erosion, organic matter decline, contamination, salinization, compaction, soil biodiversity loss, flooding, landslides, and flooding. So to improve this protection, what would be the key legal issue to answer the second question? Well, the first one would be to create an international status for soil as a natural media, and not only as an available resource. It would change the perception of soil at the international level. On that, the work of the IUCN is already amazing. I'm referring to the guide written by Ben Bauer and Jan Hanam more than 10 years ago. And that work was pursued by the writing of a soil protocol that could have been adopted at Rio +20 conference in 2012. It would have been under the authority of the UNCCD, and it would have recognized that soil is a security matter at the international level. Unfortunately, this soil protocol that is ready is not about to be adopted. The second key legal issue is to create an ecological governance for soil at local levels, and including transboundary territories. Because what we observe as obstacles to improve the soil protection is mostly boundaries. Sovereignty principle, subsidiarity principle for the European Union, for example, and at the local level, property rights. So what legal mechanisms would be necessary to address these issues? Well, we can say that the lack of knowledge on a natural element stops its recognition by environmental law. So increasing the knowledge on soils would definitely bring new tools to enforce international and local protection.
Sorry to cut off the rest of this, but we're going to make the rest of these videos and presentations available online as well. So we'll go ahead and continue.
Good morning, everyone. My name is Ana Paula. I am a master's student. I am a master's student from the Federal University of Santa Catarina. First of all, I would like to thank everybody in the organization committee, and also my advisor, Professor José Rubens Morato Leite, for always supporting these students. This presentation is part of my research, and it's about a specific normative structure for payment for environmental services and its contribution towards agroecology. Well, agriculture is one of the main activities in Brazil, and it affects not only economy but also social and environmental aspects. Modern agriculture dominates the food production system, is not sustainable. Consequently, it needs to be revised. Agroecology, on the other hand, relates perfectly with sustainable production, for it emphasizes on food security, traditional knowledge, organic fertilization, and the use of selective seeds. The instrument of payment for environmental services could be applied as a way to promote agroecology, but currently is misused, poorly used, and insufficient. This consists on the main environmental challenge. The Brazilian Forest Code addresses PES, establishing that it is a compensation originated by behaviors that enhance or preserve nature and produce environmental services. But the PES does not have a federal law which specifically structures the instrument. Therefore, it originated many different PES systems, which very often do not reflect the original fundamentals of the Institute and became distorted. Here relies a central issue, that when a PES is poorly structured, it is easy to lose focus of its essential purpose, which is protecting the environment, and this is a significant legal issue in Brazil. Another problem is that the value established in return is often inadequate when considered the amount spent and the activities that are no longer performed because of the obligations assumed on the PES. Also, commonly, the communities are not consulted, so there is no participation in the decision-making process regarding the resources involved. Musdale believes that concerning public policies, social effectiveness is the whole point. Looking for a more sustainable future, the systematics of a specific legislation about PES, which sees agroecology as one of the main areas to address, is the legal mechanism to be considered. There is a bill that, though it gives priority to small family farmers, as it should, does not mention the importance of hearing them and assuring their participation. And therefore, the participation of all parties involved is the key to make this instrument more effective, more successful. Also, when applied, this instrument has to be compatible with the specific characteristics of every region. We need